thank you so much for joining us on this much anticipated webinar. I'm so grateful that you could share your time with us. We were just waiting for a few minutes for Mr. Nidoho to join us, but I see that he's joined the call. So as we wait for him to settle, I just want to say welcome once again. This is Mikasa's live webinar on land litigation, everything you need to know. So sometime last year, we had a session with the Lands Commission with Mr. Nidoho, whom I'll introduce shortly. And we had a lot of insight. There were so many questions, concerns that we thought, would be a good thing to have another proper conversation about it. And that's why we're bringing this back. And so I can assure you that this is going to be an enlightening one. We have a lot of questions in already. We're going to, as much as possible, see how we can get into that. My name is Daniela Asariedu. I'm head of marketing and PR with Mikasa. So my guests are here. Mr. Emmanuel Matekoli. He's a seasoned lawyer with M&O Law Consult. Hello, Mr. Matekoli. He joined the call at 9 a.m. Mr. Matekoli, I think you're muted.
Yes. Can you hear me now?
Yeah. Yes.
Okay,
We can hear you now.
Thanks for the introduction. I tried to be on time.
We appreciate that. We really appreciate that. Also, we have Mr. Timothy Anidoho, Esquire. So today I'm in the middle of two seasoned lawyers. Maybe I'll be the third. You never know. So we have Surveyor Timothy Anidoho Esquire, who is the acting Greater Accra Regional Lands Commissioner. Hello, Mr. Anidoho.
Hello. I also try to be on time, only I'm slightly late. So, Senior, thank you very much.
Thank you so much for joining. And I'm grateful that you could share your time with us. So, Mr. Nido, I was saying that the last time we had a session with you, we couldn't even exhaust the questions. And even after, the questions kept coming in. And so we thought that this was right to, put together again. We're going to go right into it. So we know that land, the demand for land increases every time. It's going to increase again tomorrow next, because a lot more people prefer to, buy land and build themselves because that affords them the flexibility. It's relatively cheaper, and land appreciates. So it's a good investment opportunity for a lot of people. And so, yeah, there's high demand for it. However, the statistics is alarming. We're told that about 50 to 70% of cases in police stations and in the courts are land, followed by marital issues. So it's definitely alarming, and we will really want to find out, why this is the case. So my first question, which I would throw to Mr. Matekole, is this. So first of all, I've seen a land, right? And maybe I've gone onto Mikasa, I've seen a land on it. I would like to begin the process of buying it. And maybe I've met the agent or the contact person, the person who says they are selling this land. Before I even start, the acquisition process with lands commission and etc., what are the questions I should be asking this person that I've met? What are the very first questions I should be asking this person?
All right, thank you for the question. It's a brilliant question, but I would want to address what you said about the land litigation issue. Based on my experience, the challenge we are having with land cases is because people fail to use professionals when acquiring land. It's just that simple. If they were using professionals, it would be much easier for them. As for litigation, it will always happen. But if you use professionals, the chances are that the case can end abruptly because you can have it thrown out for lack of capacity or something. But this is a situation where a lot of people acquire land without using lawyers, and then when the lawyers end up in court, they only come to lawyers when the matter is in court. And when the matter is in court, you have the lawyer who did not help you acquire the land, and you are uh, requiring this lawyer to assist you to secure your interest in the land. When the law requires that you have to do certain things to acquire land, you haven't done them. All your documentations are defective, and you have engaged a set of a lawyer who is trying to assist you to present a case to convince a judge that the land they should declare title in your favor. So what happens is we both counsel, both lawyers, we do our best to secure a favorable decision in our client's favor. But I believe that from this discussion, you realize that a whole lot of transactions that have occurred in this country can be set aside. The only reason why sometimes a lawyer may not be able to have that transaction set aside is because if he attacks the other person's documents and the same principle is applied to his documents will also be defective. And in other words, his clients will also not have title. So you keep mute on certain things and present what you think is your strongest case to the judge to convince the judge. And that is why these things keep coming up, because once you don't have you don't have a valid title, another person can sue you, and that person may have a better title than you. So the litigation keeps recurring. I mean, that is by the way. Now, if you meet someone who wants to buy land, I mean, if the person wants to buy, the first thing you have to request for is the seller's title documents. You need to find out what documents the seller has or is relying on to sell the land. So in Ghana, if you want to buy land, you have to find out whether the person has a good title. So a good title can be possession. If you've been in possession for um, about 30 years and you have documentation going all the way back to 30 years, then you can say that that's a good title. If you have a court judgment, which where there is no conflicting judgment by a court with concurrent jurisdiction, you can say that you have a good title. Where your title is conferred by law, then you can say that you have a good title. So these are some of the circumstances under which you can be rest assured that if the person falls within these categories, you are basically procuring a good title. Or if you are getting title from Lands Commission, where Timothy works, then you can be assured of getting a good title. Now, after you've procured a good title, there are certain steps that you have to take in order to also perfect that title. And I mean, I believe that we'll get into that. So I believe I've answered the question.
Yeah. Okay, so I mean, let's dwell on that a bit. So,
Okay.
in assuming I see a land and the person selling it to me, um let's say it's a family land, right? And
Yeah.
and we see a lot of those.
Yeah.
If it's a family land, how do I know for sure? So does it mean that whoever is selling it to me, that is saying is the representative of the family? Um, if they have the title, then I'm assured that they are safe enough to work with.
So, in law, there's no easy answer. When it comes to conveyancing is one of the most technical areas of law. And so a lot of it's not in the comfort zone of a lot of lawyers. But let me just make it clear to you that, you see, if you meet a family and you want to buy property from that family, first of all, you have to establish whether the person you are dealing with is the head of family. That's number one. And you also have to establish who the principal members of that family is. So we need to establish who all the principal members are. Now, the rule is that if you are transacting on family land, the document must be signed by the head of family, with the consent and concurrence of the principal members of the family. And when they say principal members of the family, they mean all of them. That's what the law is saying, all of them. It's not just some of them. If you are not able to get the head of family to sign, the proper head of family, not just any member who claims to be the head. If you cannot get that proper head of family to sign, then it means that the transaction can be declared void. If you cannot get all the principal members of the family to execute it as witnesses, then it means that the transaction can be declared void. So what I normally do is this, because it's difficult to ascertain who the family head is. And the law has tried to make provision for that to be addressed. But what I do is this. I do a family resolution. So for instance, the land is in Pram Pram. I'll do a family resolution and try to get as many members of the family as I can, even if they are 50 or 60. Now, I would want all of these 60 members of the family to basically, in that resolution, state that this person is the head of family, or they want this person to transact on their behalf by signing the document. And they want 4 people to witness the documents as principal members of the family. And these are the only 4. And this family resolution will be referenced in the deed, because there's no way of me verifying who the head of family is apart from what the people have told me. So I have to capture it in writing. And in our courts, it is about what you can prove. If I have gone to the family members and they have told me that this person is the head of family, it has to be in writing. If they have indicated that 5 people should sign on our behalf, it should be in writing. So I believe that the family resolution addresses this issue for now. Now, the Lands Commission has also come up with a system which they call customary land secretariats, which is supposed to register the interest of customary grants and stuff. So assuming that the family acquired the land orally through an oral grant, maybe from a chief or something, the customary land secretariat is required to register this interest in their records. And if I do conduct a search, I should be able to find out that this is the transaction that took place. These are the people who were involved in the transaction, and I'll deal with these people because there's a record. Unfortunately, and maybe Timothy can correct me, but I have not come across many families. Only about 1 or 2 families that I have heard of who are, you know, have basically have established a customary land secretariat. It's only a few families, but the practice is not pervasive enough. So I think the customary land secretariat is one way of addressing it. But in the meantime, maybe the family resolution I'm proposing is also another way.
Okay. Right. So now let's move to the next step, and maybe Mr. Nudoho can come in here. So after you've met the appropriate persons, they have the appropriate document to show that they are indeed the rightful owners. They're in the right place to sell you this land. What then is the next process?
Good. That's a very good question. So let me just finish it then. You see, once they show me that they are the rightful persons to sell the land, now I have to vet their documents. Because you see, under our law, the rule is that if somebody has a document, it can be a contract of sale or it can be a transfer deed. The rule is that that document must be in writing. So when they say writing, it means that it must have the name of the parties, the consideration, description of the land, a proper site plan, right? Then it also says that it is not enforceable unless it has been signed by the grantor or the grantor's representative and witnessed. Now, when they say signing, if it's family land, the signing requirement is that it has to be signed by all the principal members of the families as witnesses and by the head of family. Now, when they assuming that the principal members of the family are people who are illiterate and therefore they printed it, then it means that there must be a jurat clause in there to show that it was read to them and they understood it. Otherwise, the execution is invalid. And what that means is that that agreement is not enforceable. So I have to go back and get them to do the right thing so that my client's grant, assuming a grant is, my client takes a grant from them, cannot be attacked on the basis of a defective document. Do you get me? Because land transactions, you look at antecedents. You look at what happened in the past, and if there's an error, you have to correct it before you basically do what you ought to do in the current transaction. Otherwise, you'll be affected.
So
Because the
are we
continuum.
sure that everybody else is going through this process?
No,
Because
that's why I'm telling you that if you use a lawyer, you can cure a lot of these things.
right.
And I believe Timothy will agree with me. I think I've spoken enough. Let Timothy also come in.
Yes, Mr. Nido.
Cause you're in the job. You're in the job of speaking. So
yes, so I'm trying to find out. So after that initial conversation where they've shown you documents that seem to prove that they are in the right to sell you this land, what then are the next steps?
I think council has spoken about the essentials of the background that you need to look at. So once the document is prepared, then you are leaving your council's domain. He kept emphasizing a few things. He kept saying some things that I think we have to emphasize on. He was strong about using professionals. In Ghana, it's only a lawyer that can prepare a deed for you. He kept saying that because if you look at the complexities of how to acquire, if you don't use the person who understands or knows the processes, then you are likely to fall into problem. I'm sure most people online now would have acquired the land on their own. They went, they saw it, they liked it. You'll be even lucky if he did a search or he did any inquiry. It's just that, oh, the land is lying there, it's flat, it's nice. So he goes, they give you some indenture, and that is it. So please, the advice he gives about using professionals is key. Also, the nature of vetting the documents that the grantor is claiming to have given to you. He says he's a family head. Is that what is recited in the document? Or is it that suddenly the family land now becomes a stool overnight? Or is it his personal land that he's assigning to you? So after you have done what council has advised us so well to do, you will now have what we probably call the indenture or the deed or the documents that covers the transaction. So I'm assuming everything is done right. That is where the formal structure, which is the Lands Commission, would come to play. There will be three essential steps. One, you go to the court to get the oath done. Then you come to the Lands Commission for what we call the payment of the stamp duty. Then you submit for registration. If it is two land, you have to do the consent or concurrence, which the Lands Commission will grant to you before you proceed to do the title registration. So this is briefly the steps you take after you have done what is right. And people should know that the fact that you have a deed and you submit to Lands Commission doesn't mean that it's by all means going to be registered. That is where people have a challenge, because the commission also does inquiries in its records of whether that same parcel has been registered before, whether we have any information on that parcel, whether the state has acquired that parcel in the past. So when you submit your document, I always use the visa as an example. The fact that I pay for a visa today doesn't mean that I would have the visa. The immigration officer would have to look to see whether I am qualified to have the visa. It's only when I'm qualified that he would issue me the visa. So for us also, our registration is solely, so people come and say, oh, I have an indenture, I've submitted it, why haven't you given me my title? Lands Commission's job will be to investigate what you have brought against its records. Then it can advise whether it's a registrable instrument or not.
Okay, so if I'm getting this right, it means that, so what will cause somebody who has brought you these documents not to be successful in registering?
Okay, that is key. So there are a number of issues. One when you submit your document, we would have checked it against our records, as I stated. So I got a document from X family, and to follow council's example of Pram Pram. Then you bring it to the records. Lands Commission looks through its records and finds out that that same family gave it to you, Daniela, some years ago, and you have registered it in our records. Obviously, you get a small love note from Lands Commission saying your document affects a transaction already in our records. So that can halt the process. Two, your the parties may have omitted some essential elements of the agreement. For instance, the recitals may not speak well of how they got it. So we've checked our records, and Lands Commission doesn't find any tracing of the person who gave it to you having recorded anything in the commission. That will lead to further inquiry. It may not stop the process, but it may cause for further inquiry. Another reason why we may stop the process is where your plan is erroneous. For instance, it is a tight plan that you submitted to us with the belief that it described aptly the land that you are going for. Maybe during our process of inquiry, we found out that that site plan seems to describe a totally different location, or a location that is not what you intended to register. So these are just a few of the things. As I said, you need a lawyer to endorse a document. These times we try to sieve these things at the beginning point so that we don't even receive the document to have challenges. If it is two land, the constitutional requirement is that it conforms to a development plan or a proposed development plan. If you write to the assembly and the assembly says this land is, say, wetlands, or it is a Ramsar site, or it is for a playground, a public playground, then if you bought it for residential use, the commission will write to you and say, we cannot progress because the land is not, does not conform to the zoning status.
Okay, so then what happens if in a situation like that, the process has to be stalled? Is that the end of it? There's no hope for this person?
Yes, so always people, once a public service writes to you and says, this is the challenge, you now have to come ahead and explain why that challenge should be overlooked. And we can give you a provisional certificate, for instance, in some areas. So we can come back and say, look, oh, I have built my house. I've been it for X number of years. Nobody has challenged me yet. Then we can say, okay, we want to come and inspect and see whether you are in occupation, whether you have built a house there. That would help the officer look to how to progress with the process. You may not end up with a full certificate. You may get what we call a provisional certificate. Some of it even may require you to see your lawyers to, for instance, where there's adverse possession, where you are claiming that for 12 years you've been in occupation. We will advise you that go see your lawyers, let them institute some action to be able to get what we require by some court decision to help us look at your transaction. What people do mostly is that once they receive a letter from the commission, they go to sleep and assume that, oh, he's written to us, they said it's not doable, so I have given up. But if you have more information that you can give to the commission to assist it in making a decision, there's nothing wrong with writing back and saying, hold on, I've heard this and that and this, but this is my situation. Can you look at it in this manner for me? And the commission will look at it.
So does this mean that until you have gone through the process to a certain extent, you shouldn't be making payment to whoever is selling you this land? Because I'm assuming that if I made some down payments, and of course sometimes some of these people selling lands can give you some pressure. There are people who want to buy the land, doing some down payments will guarantee you the land. But maybe you do that down payment and then you begin the process and you hit a wall at a point. Is this saying that it is not advisable to do any down payment whatsoever?
Sorry, let me
I'll
just
leave
come in.
council. I'll leave council to do the payment issues.
No, 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 no. No, you see, there are three stages of the transaction. There's the pre-closing stage, there's the closing, and then there's a post-closing stage. The Timothy is talking about the post-closing stage, which is the registration at the Lands Commission. But if you go through the pre-closing and the closing stage, you will not have the challenges that he's talking about. So at the pre-closing stage, when you have engaged the service of your lawyer, and I insist that you use a lawyer, they also verify whether the lawyer is in good standing, because a lawyer who has been suspended cannot draft a conveyance. It is to be invalid. That's number one. So that's the pre-closing stage. Now, after that, you have to get the lawyer to do the due diligence for you. So the due diligence, first of all, the law says go to Lands Commission and go and do an official search. Official is different from unofficial. Official search, you have a person at the Lands Commission signing it, that the search is, is from them. So you do an official search at the Lands Commission. Then after that, you do a search at the zoning authority. We call it Land Use and Spatial Planning Authority, to find out whether the land has been zoned and for what purpose. That's what Timothy was referring to as the development scheme. Then after the zoning search, then you do a search at the High Courts to confirm if the land is under litigation. Then after that, you also do a further search if it is stool land or family land in the Greater Accra region. You do a further search at the Office of Administrator of Stool Lands to find out whether ground rent is owed. Because if ground rent is owed, it means that there's a lien on the land. And even if it is sold, the owner can basically re-enter with notice to you, of course, and basically take the land back. That's what we mean by re-enter. Once this list is not exhaustive, I'm just giving you some of the things that have to be done. Once all these things are done, then you get the lawyer to do a legal opinion, which we call a title report, advising you that these things have been done, and for this reason, you can go ahead and purchase the land. This title report is very important because now it shows that in the court of law, assuming you go to court and you present it as evidence in court, it will show that you were being prudent, because the principle is caveat emptor, buyer beware. You came in, engaged the service of a professional. The professional did his or her due diligence and advised based on their findings that the land is good and therefore you ought to purchase it. And if that is the case, then the court would be able to put you in a category called a person who bought in good faith. Now, if the lawyer was negligent or based on some false information, also based on the negligence, gives a wrong opinion, it will be captured in writing. And under the Land Act, professionals who give false information are liable to some penalties and stuff like that. So that is also some form of indemnification for you. Once all this is done, which is a pre-closing stage, then now we move to the closing stage where the documents are being prepared, where correctly my colleague said that it has to be prepared by a lawyer. Then after that, after the preparation, we look at the execution, ensure that the document has been properly executed. And then after the execution, then now we go to stamping. Now the law is that the stamping must be done within 2 months of the creation of the document. And the document must be presented within 3 months of its creation, because the rule is a person who presents the documents first is the one who has priority. So somebody may have gotten a document on a piece of land, the same piece of land, in 1980, and presented that document for registration in 2024. Whereas somebody got their document in 2023 and presented it for registration in 2024. Maybe the 1980 person will get his certificate earlier, and the 2023 person may get theirs later. But when it comes to priority, they will give the 2023 person's priority. They will not say because your document is dated 1980, therefore the 1980 document should take precedence over the. No, it's about when the document was presented. So after that, then now we move to the Lands Commission, which is what my learned colleague was talking about.
I see. Uh, I don't think that a lot of people are really privy to all these steps because
Exactly. That is why I started with
yeah,
that.
I don't think so at all. So does this mean that if somebody goes through this entire process that you listed now, it is not possible for them to have any issues whatsoever now or in the future about their land?
It will be difficult because you see, with law, we are looking at the process. We are not looking at we are looking at the process more than the outcome. Do you understand? So, for instance, the law is that the land registrar shall not register family land, stool land, skin land without the consent of the family, the stool, the skin, or the land registrar shall not register stool land, skin land, family land, I mean whatever land, if on the face of the documents the covenants have been breached, and then the land registrar registers it. What happens is that that certificate is void. If it goes to court and you can prove that at the time the registration was being done, the covenants had been breached, then it means that that registration is void. So in law, the procedure and the process matters more than the outcome you desire. Yes, a land certificate gives you an indefeasible title, but it says that you must do everything in accordance with the Land Act. So if you go and get a certificate and you don't do the things in accordance with the Land Act, then it means that that certificate can be set aside. So people have certificates and they are in court, and their certificates are being set aside because they didn't follow due process.
Right. Very, very interesting. So let's assume that, okay, so this person has gone through all the right processes, etc. They've gone through lands commission, they've acquired the land. Is there anything else, any do they have to be proactive in any way after everything to still keep their land? So people are being told you have to wall your land, you have to do something on it. If I have all the right documents, why do I need to do this if I'm not ready to use the land
Absolutely.
yet?
Yeah, you have to basically take possession of the land, because you see, in law they say that possession is 9/10 of the law. In fact, the rule is that a person in possession of land is presumed to be the owner of the land until you can prove otherwise. So if you have a certificate to the land and you are not in possession, and somebody enters into possession of the land, and you do not take steps, maybe you are in the UK or the US, to remove that person from the land or to put that person there at your instance, what happens is that the person can accrue certain rights, where one, they are protected by law because of the Limitation Act. The Limitation Act says that if you enter into possession of somebody's land for 12 years and the person does not resist your occupation of his or her land, then it means that the person has abandoned their right to sue you. Then there's also the principle of adverse possession, also in the Limitation Act, which says that if a person exercises possessory rights to your land, with the intention to remain there by putting up a story building and all of that, and you are there for 12 years and you do not resist it, it means that person is in adverse possession. Then there's the principle of lashes. Lashes is where you have delayed in going for your land because you've waited for the person to build, and then now you're saying that you want your land back. Lashes will get you. So even if the 12 years doesn't get you, you can be caught by the principle of lashes and acquiescence. And there's also the principle of estoppel by standing by. So there are so many things that um, are so technical. It only takes a lawyer to. It's not like I'm doing any adverts for the lawyers, but I've gotten to the point where I feel like if you allow those who are trained to do what they are supposed to do, it will minimize the problems. in our society. Sometimes you get a matter and you are so emotional about it because you know what is being done is wrong. But the law is not about what is right or wrong. It's not about what is moral or immoral. It's about what is legal. And what is legal may be wrong or it may be right. But if you go to court, it is only law that we speak. So maybe sometimes a judge may give a decision not based on law, but based on morality. And that decision will be challenged and it will be overthrown. Because we are all human beings. You can see that the person has done a wrong thing, but legally the person is protected. You see.
Yeah. Mr. Nido, would you like to add anything to this?
Sorry. Yes, he makes a good point again about the possession. And unlike other commodities that we purchase, like a car, you get to drive it home, you've not left it where you bought it. Land has its own unique features. And because you are going to leave it in a fixed location, if you don't take possession of it, you are just going to be leaving some opportunity for litigation. In the more rural areas where there's no pressure, you may not have the same experience as you would have in an urban setting. But acts of possession in law are critical to add to your possession, your acquisition of rights in land. So if you buy land and you leave it bare, as in with no acts of possession, you may be leaving room for litigation. And as he describes the processes that you go pre-registration and all those things, post-acquisition, all shows you that the purchase of land requires some diligence. It must not be taken, and you made an example, Daniela, about the fact that you would have made, there'll be pressure. You may have made some commitments. Once you do the commitment based on pressure and not your understanding of whether the person has a right or not, that is the first slippery ground you'll be entering into. Because now when you start doing the inquiry and the person doesn't have the rights, then you begin to have challenges because you would have committed money already, which is very common in this part of the world, where the person would have told you, oh, give me X amount of money as a commitment. But if you get a commitment before you start making the inquiry, then what happens if the inquiry goes wrong? So I say it's just a risk you are taking, a huge risk. And I've noticed that most people who have the right documentation are not hesitant in giving you what you require for inquiry. Usually what you find out is that those without the right documentation are likely to rush you into making commitments when they've not provided much for you to inquire with. So he comes and says, please give me half amount. I'll give you site plan in 3 weeks, 4 weeks, or I'm going to do the documentation. When you start asking for the to when meet the family head, the person say, oh no, just deal with me. I'm the middleman. Once you start making inquiries and you don't have the ability to meet the right people. Even if an individual is selling, they said this Mr. Kwame. Who is Mr. Kwame? Where does he stay? Do you have evidence that it's Mr. Kwame who is selling? Then you can start dealing with the person. But in Ghana, and 80% of our challenges, if I'm not without statistics, from where I sit, is that people just don't make inquiries before they commit financially to transactions. They just follow advertisements, they follow word of people, they visit the land and they start making commitments without using the professionals, without doing any inquiry, and they start putting money into the business.
Right. So, I mean, when we're preparing for this webinar, one of the questions that came in was that, how is it possible for somebody to just get up and sell one land to multiple people? So does this mean that it is we, the buyers, who make it easy for people to get up and sell one land to 5 different people? Is that what it means?
Well, there are two ways. My experience is that the seller can sell to 2 people because maybe, and just maybe, he sold to Mr. A. Mr. A never took steps to record that transaction in any public record. He never, as counsel was saying, he's never stamped the document, he's never registered. So it gives room for him to sell to a second party, because when the second party makes inquiry, for instance, with the Lands Commission, there'll be no evidence. That first party also may have not taken any act of possession, left it in the bush, and he's gone. Maybe 5 years, he's out of the country, he's never visited that site again. So it also gives room for people to believe that the place is available. So we, those of us who purchase, should be able to take steps as soon as you enter a valid transaction to take possession and give notice to the whole world by forms of registration. And mind you, double sale, it's a crime. But we, the people who also purchase, when we find out that the person selling has sold to two people, we are content in litigating amongst ourselves rather than going after the purported grantor who himself has created the problem, because we are afraid to offend the establishment, which is maybe if it's a stool or it's a family or it's some, we are happy to be litigating because we, both of us, are fighting over who got it first, rather than roping our grantor into such things, because the grantor himself has committed some crime and he has done something wrong. But 80% of the time, we leave the grantor and go fighting amongst ourselves because nobody wants to offend his future landlord. And I think these are some of the things that creates the problem of double sale.
Right. Mr. Mateka, did you want to add something?
Well, he's absolutely right. You see, the law is designed in such a way that if you try to follow it strictly, you minimize the risk. You minimize the risk of you losing your land. Now, I will go back to the same point again, that multiple sale, for instance, can be addressed by, for instance, entering into the documentations prescribed by law. So, for instance, before you buy land or you pay for land fully, you enter into a document called a contract of sale or a sale and purchase agreement. In this document, you are going to prescribe an installment purchase, a payment by installments, rather. So, you pay based on certain milestones being achieved. So, for instance, if you have done your checks and you find out that maybe the owner has not registered his title, you make it a condition precedent to a payment of a certain amount that he ought to register his title, because if he doesn't register his title, you also cannot register your title. If you make it a condition precedent that before you make a second installment, that you have the access to the land and that you can go and test the soil and put up maybe a small wall on the land, and based on this sale and purchase agreement, and that is done, you will find out that maybe some people will be coming out of the woodworks to challenge you. Once that is done, you know that, hey, look, if this person doesn't solve this problem for me, I'm not going to pay the rest of the money. So these are some of the ways you can put the seller in check by entering into a contract with them to ensure that all these practical things are dealt with before full payment is made. Because land transactions, you don't buy them like you are buying groceries. You take your time and you do the transaction in such a way that you're absolutely certain that you are not buying into a problem. So that is one way of dealing with conflicting grants.
Okay. Now let's talk about giving lands as parcels of land as gifts to other people. And we have a question here that came in earlier. And he said that I was giving land as a gift by a relative who has since passed away. He added another piece before dying. The indenture was for the original gift. Where do I stand? And we've seen cases like these. Somebody gives a parcel of land as a gift to another person. If I don't want this person to encounter any challenges in the future, what is the right process to go through?
Well, so there are two gifts. There's the customary one and then the statutory one. So if it's a customary gift, then it ought to be registered with the Customary Land Secretariat, as I had already indicated. And then, customary law, they say knows no writing. So it means that you can actually give somebody a gift in customary law without putting it in writing. But then under the Land Act, the law prescribes a form which you can actually use to capture this customary gift. So once this customary gift is captured duly, it will be stamped in the document, it will be stamped and registered. And it will constitute notice to the whole world that there's a gift in your favor. Now, if it is the statutory one too, that one has to go in accordance with the Conveyancing Act, where you have to basically, it has to be in writing by all means. It has to be signed by the person who gave the gift and witnessed by the person who gave the gift witness, and signed by the person who is receiving, the donee, and the donee's witness. And then it also has to be stamped and registered. Once the registration is done, in fact, even if you do not do a search on the land, you are deemed to know of the fact of the ownership, even if you don't do a search. So the registration is key. The registration is key. But if another way of doing it is, if it's a customary gift, you also need a lot of witnesses. And there's a way of giving gifts according to various customs. So the witnesses are able to attest to the fact that the customs were followed in the giving of the gift.
All right. So in this person's situation, he says that the indenture was for the original gifts, which means that he has nothing for the second. Where does he stand?
Yeah, but what I'm saying is that the indenture for the first gift was done in accordance with statutes. That's what he can argue. Because if it is by statute, it has to be in writing. It has to be witnessed duly. It has to be, all that has to be done. So the first one can be done, but he can argue that it was given to him according to the Conveyancing Act. But the second one, he can argue that it was given in accordance with customary law. But if it was done according to customary law too, I don't know whether it's a guy, a fancy, then it means that he has to ensure that that customary grant is recorded. Unfortunately, the person too has passed on. But even if the customary grant is not possible for the customary grant to be recorded, he can do a statutory declaration, reciting the fact of the gift. And if there were witnesses present and the customs were followed, all these facts ought to be recited in that statutory declaration, and he can present it to the commission to do a first registration. Timothy can correct me if I'm right, or if I'm wrong rather.
Exactly so, counsel there. As he explained, he has nothing. So he needs something for us to register. So he can't come to us with nothing. If the person who gave him the gift has a customary successor who recognizes that gift, then for us, registration has to do with documentation. So he has to go to the person's customary successor, and if the person would affirm that gift for him and put it in some form of a writing, and then he can come to us. Obviously, it's a land document. So the basic tenets of what a land document should have, that gift document would have the same. He would do a site plan, for instance. In the recitals of the document, we indicate the person's capacity to grant, and then also why he's gifting him and what the reasons for the gift. And then Lands Commission is ready. So he should go back. If Mr. A gave it to you and Mr. A passed, then you can use Mr. A's customary successor or whoever the person who inherits him is. If he can regularize what the person before did, then that's the only way you may be able to get some documentation to bring to us. Yes.
And
Okay,
additionally, sorry, if the person has passed and there's a personal representative and the deceased name is registered at Lands Commission, he can actually have the personal representative assuming the personal representative can confirm that this was done, you can have the personal representative apply to the Lands Commission to have a certificate registered in the personal representative's name. So it will say that Mr. A in trust for the deceased. Then that personal representative can now transfer both lands to him.
All right. So does the same reasoning apply to wills and inheritance, leaving parcel of lands as inheritance without having a will to back it? Does the same reasoning apply?
But how are you going to give out a parcel of land? Are you talking about by way of gift or what?
No, so let's say my father had land and
Yes.
he's passed, but naturally I inherit his lands. But there's nothing
So
really to show for that.
So there's nothing in law which says that when your father passes, naturally you inherit the land. So what happens is that you either die testate, which is with a will, or you die intestate without a will. If you die testate, we are going to look at your will to see who the property was devised to. If you do not make a will, the law will make a will for you. And the law's will is that if your father has passed and your mother is alive, then it means that your mother and your siblings will all take the property together. If it is one house, you all take it together. I hope you understand. So it doesn't it has to go in accordance with law. The devolution has to go in accordance with law.
Okay. All right. Now I want us to talk about lands commission and your documentation, the processes and all of that, Mr. Nido, because we
Yes,
have a
please.
few questions here. So this person says, how is it possible that someone can buy a land, do a search and find it in their names, and then after a few years another search shows it is in another person's name? Is this possible?
Okay, so what he's saying happens rarely. Once registration is done in one person's name, unless that person is transferring it to somebody else, it shouldn't be possible. So, like I explained initially, once your name enters the register, it can only be superseded by another name, whether by some court judgment, direction of some courts. That those are the, or there was something patently wrong on the face of it, assuming there was some error in the plans. Your plan should have reflected a different thing or not. But even that, you have to be informed before. And I say, admittedly, in a few cases, this has happened. But there's always room for correction. People have come back, drawn our attention, and whatever was the basis of that error, if it is an error, we explain. If it is an order of some superior judicial authority, we would explain. Maybe you should be able to take some action to restore it. But it shouldn't happen in such that you have a registration and suddenly it disappears and somebody else's registration takes over yours and you can't do anything about it. That is not the case.
Okay, all right. So there's also another one here that says, if my land, which is registered or plotted earlier at Eastern Region, is recently registered by another person in Accra with land title, what do I do? I don't know if the question is clear.
Yes, it's clear. You know, the boundaries of the
Okay.
regions have become fluid over the years. So it happens in the Kaswa area, for instance, which used to be part of Greater Accra and now is within our registration region of Central Region, administrative region of Central Region. It happens in the Brekusu area. It happens in areas where the regions share boundaries, because the administrative boundaries keep changing. Now, the law will look at the first in time in registration. So people should not think that because the first one fell here and I came and I got a land title certificate. So there's Currently, at the commission level, there's a committee that has been established at the board, the national board level, which is supposed to look at resolving all the issues that have to do with the boundaries of regions. Technically, what should have happened is that once the demarcation was done, the commission should have transferred all the information that existed before that redemarcation of the regional boundaries into the new region, so that it will be difficult for people to come and re-register that same land in another person's name. So there are peculiar places that we've noticed that has begun to rise often. So the commission has a committee headed by the Eastern Regional Chairman, who is looking at resolving these matters and making sure that we don't have those situations arising in the future.
Okay, all right. So, ladies and gentlemen, the floor is open for questions. So there's a question and answer session on your interface if you look at it. So there's Q&A. You can drop your questions there and we'll ask them. But we'll continue the conversation as we intersperse them with questions. So you can keep them coming, and then we'll read them and have them answered as much as we can. So I think this question will go to Mr. Matekoli. It says that who is in charge? Who is meant to enforce judgment on land issues settled by the court?
So it is the party that's the victor. It's called the judgment creditor. Judgment, the person who wins is the one who is supposed to enforce it. So what happens is that there are stages. So you take a matter to court, you get judgment. But if you do not take steps to enforce the judgment, then it just remains a judgment on paper. So the person who wins is the one who should take steps to enforce the judgment.
Okay. I'm just thinking, does the person shouldn't that rather be someone with some authority of a
Yeah,
sort?
so okay, I didn't want to be too technical. So there are various ways of enforcing a judgment. So let's just take it that the property is about title. Somebody wants title to land. And so two parties have gone to court. They've fought, one person has won. What the winner ought to do is that the winner ought to bring a writ of possession to the courts for the court to grant it. And then once the writ of possession is granted, you go with the assistance of the bailiffs and sheriffs and the police to remove the people from the property by force. That is how you enforce a writ of possession. There's also what we call writ of
Right.
fife. Rate of fife is, assuming it's a money matter, and you want to recover your money, you can attack somebody's property, sell it, an auctioneer will sell it, and then you get your money. Then there's garnishee. Garnishee is where you identify the person's bank account, invite the bank manager to court to confirm if the person has an account there, and then the balance will be stated. The court to make an order that the account is frozen and paid into your account. So these are the modes of execution of the judgment.
Okay, I understand why you didn't want to be technical. I get
Yeah.
it. So there's a question, UG, um, that says, what happens when you buy land, which you verified from Lands Commission, but after purchase, you are served about a month later with a court decision showing that the land belongs to a new owner, different from the person you bought the land from? Are there any remedies available to the buyer?
Well, can I start?
Yes,
Absolutely,
yes, please.
absolutely. Look, a court judgment is impeachable. A court judgment is very impeachable, and I've realized that our culture is that we don't like litigating. So people go to high court. The high court says no, then oh, I don't want to go again. The high court judge is just one person, and like I said, you see, there are people who are swayed by various considerations. Some could be moral, some could be ethical, but if it is not a legal because if a legal consideration, the judge must provide the legal basis for the decision. And if the judge cannot provide a good legal basis for the decision, you can appeal. And there are several appeals that have occurred that have overturned high court judgments. And then there's the appeal court too, who also you can appeal to the Supreme Court. And there are several appeal court judgments that have been overturned by the Supreme Court. And the Supreme Court in itself has reviewed its own decisions. So that is how come there's a recent decision where 40 years after a family has won a case. Anyway, let me go back to the question. Yes, you can because you see we're not a party to the case, and the rule of thumb in litigation is that the other party must be heard. It's called odi alteram partem. A court does not have jurisdiction to hear a matter or to make a valid determination if the person that the determination is going to affect is not a party to the suit. So if I bought a land before a decision was given by a court, then I have every right to go to the court to basically let the judge understand that my side of the story has not been heard, and therefore this judgment should be set aside because the land was bought before the judgment was given. If the judgment is given and then the land was bought subsequently, that's a different matter. But if it's before, you have a cause of action.
Okay, great. So this one also says, I've acquired a land around Bojiase from an
I
estate
think Timothy
company.
wants to say something.
Okay,
No,
Mr.
no,
Nino,
no.
you want to say something?
Oh no, I was just saying that just simply people don't read judgments, even what even the court is giving to the person in that judgment. People don't know. People just go see a judgment and start believing that, oh, he's got a judgment. Sometimes you read through the judgment and the order has nothing to do with the person's grantor, has nothing to do with the person's interest, has absolutely nothing. But people just see a judgment. They assume that there is a judgment and therefore they just go ahead and believe everything that is in it. So please, just a caution. If you see a judgment, be sure of what orders are in the judgment. Be sure whether it affects your interest and how it affects your interest or your grantor's interest before you start running around helter-skelter. And the person people are virtually running around with judgments that give people no right. They've not got an order to, because you have to enforce the judgment even after you have received the judgment. But people don't look at all that. Once they see some judgments walking around, they begin to panic. So just to add a little bit to what counsel indicated.
Right. Thank you so much. So this one says, I've acquired a land around Bojiase from an estate company and I've been giving an indenture. What's the next process for me to secure the land? I think we've gone through this. Yes. Um this one says, how do I get a stamp duty?
You have to take the document for assessment at the Land Valuation Division of the Lands Commission. The Land Valuation Division is one of the divisions of the Lands Commission. So you take your document to them to assess. Now, there are two things that will happen or might happen. They may choose to take the purchase price and apply 1% of the purchase price and as a stamp duty. Or they may decide to go onto the land to do a revaluation of the land. And when that is done, then they'll give you a percentage, a 1% of the value that they come up with as stamp duty, which is a tax.
Okay. All right.
Exactly so. It's important to understand that it's not the value that you place in the documentation. It is the value that the division, land valuation division determines. So that should be some caution so that if you are buying, you are not relying solely on your purchase. It may be the same as he indicated, but it may be different also if there are variations.
All right. So this question says, is there a system of checking if a land you want to purchase is already in court?
Yes, and that is why I mentioned the High Court search. Unless the matter has traveled beyond the High Court, then maybe, but if you can do a search at the High Court. So, for instance, if the land is in Accra I'll do a search at the Accra High Court. If the land is in the Adenta environs, there's a court, a high court in Adenta. If it's in Tema, I do a search at the Tema High Court. But you just do an initial search there, and if there's litigation on the land, it will pop up.
Okay. All right. I think this question also, we may have touched on it, but I'll just ask, how is it possible that a landowner can have an indenture but yet to get the title?
Well, that is so simple. The indenture is just an agreement between two parties. So I have my land and I've given you. If you don't come and register, then it stays as a contract between the two parties, or a document on which you can sue and be sued on. But registration is another leg of it. And it's important that once you've entered that agreement, you should be able to make further steps. A mistake many people do is once they see somebody holding an indenture, they presume that that is a confirmation of the person's title and may go ahead and even do a transaction based on that. Please, that is not the case. He may have an indenture, but that instrument may not be registrable because the root of title may be wrong. It may affect a government acquisition. There may be many reasons why that instrument may not be registrable. So please, a mere holding of an indenture will not guarantee the person's registration, process of registration. So people should be cautious. If he has one, still get his site plan, run your checks, follow the procedure that has been outlined earlier on before you enter any transaction with that person.
And to add to what Timothy said, if you buy land from somebody who has not registered their title, they simply have an indenture. It's not possible for you to register your document. It will be impossible for you to register your document unless that person has registered their document. All right. So I think that a novel thing that has been introduced in the law is that now the law requires that all allodial owners. So allodial owners are the people who actually what was it called? The transactions originate from them. They are the first people who give documents. The law requires that allodial owners must register their title to the land. And this is free information. And that's allodial owner. When you are registering, you will not pay stamp duty. It is exempted from stamp duty. So you're not going to pay a lot of money. They're exempted. And if an allodial owner should sell land to you without it being registered, it's a criminal offense. Now, it's a criminal offense. It's in the law. So you
Right.
try and buy from people who have registered, or it will make it a condition precedent to the sale that the registration is done, so that you can also register.
All right. May I know how long a land registration takes? I started a registration process for a land situated in Adenta in 2019, and I'm still
Yes.
waiting.
Okay, so I would wish to know what progress the person has made over the years. So as I indicated, there may be processes. I want to set an example. There's a friend who started registration in 2015. So I made a presentation and the person said, "Oh, you are lying and it's taking us 9 years." Only for me to find out that Lands Commission had contacted the person by the person's last known address as far back as 2016 and written a letter indicating that this is the issue. And the person was not responding. All right. Just 1 minute, I'll be with you. And the person had not, because the person used the last known address, the person had not received the letter. So it will be good for whoever has submitted the document 2019 to just make an inquiry. Now we have a client service access sheet. Bring your submission document. You may be surprised that some communication would have gone ahead to you to do something or bring something, and you have not either gotten that because the address used in the documentation is not an address that you still use or you are familiar. So, but the law, the Act 1036, foresaw this challenge. So the provision in the law is that within 90 days, the commission should be able to tell you whether your instrument is registrable or not. It doesn't mean it would have completed the process, but it should be able to tell you whether your instruments can be registered or not. And that's a big step from where we used to be, where it used to be agile. It could take like forever. Our last statistics between 8 to 9 months. If you are not in Accra and you are in the regions, some take maybe shorter. In Accra, because of the titling process, you may have some quickly, maybe for 6 months, 7 months. But we are working on obeying the law 100%. Otherwise, people like council will start suing us and telling us, why haven't they heard from us in 90 days? And it will make it difficult, yes.
All right. So I think this other one is also will also come to you, Mr. Nido. It says that why don't we have land registry offices or desk in other regions? I think do you have land registry offices? It says, is it not key to ensuring ownership of land?
Sorry, is it to me or Timothy?
To Mr. Nido, yeah.
Yeah.
So yes, so we have in Ghana, we have two systems, parallel systems of registration that we do. So we have the deeds registration system, which was what we used to do from independence all the way to 1986 when we started title registration. Unfortunately, title registration started in the most difficult and complex region, which is Greater Accra. So the whole of Greater Accra itself was not even declared a registration district until 2006. Before then, it was only 4 registration districts. I think what they call registration districts. So in Ashanti region, we have a central part of Ashanti Kumasi for registration again. Ultimately, Lands Commission is considering moving titling to many regions, but it has to be gradual because of the nature of title registration. So, because you need a robust survey system, because you need your plans done in a particular way. So, those who are in other regions, it doesn't mean you have not registered. All it means is that you have done it under the deeds registration system, which is the highest form of registration in those regions. And I'm sure pretty much soon, Lands Commission will carry, maybe we are looking at Western region or declaring the whole of Ashanti region as a registration district. Once we are able to put in place the fundamental structure of the survey, which will help us do the plans that we require.
Okay. All right. This one says, is there a way for the Land Commission to detect if an indenture executed in the name of a family or a person in their records is actually from the original family or person and not from an imposter?
Yes, so some families have taken a second step. Council talked about this customary land secretariat, which is a provision of law now. So now it's not just a voluntary thing anymore. Section 14 to 18 of the Land Act 1036 now says that customary land secretariats should be established. But before then, and even now, whilst we try to help them establish, some families have taken steps to inform us about what the signatures to their family land is, who the family head is. And if we have that information, we can help. If it's a stool also, they give us, maybe if they install, we go to the House of Chiefs for a certain register. We know signatories, we get to know who the principal members are, if it's a family, or the principal elders are, if it's a stool, because they nominate some persons to be the signatures. Once we have that, we do those cross checks when you submit your documents, and we can advise. But once again, the proviso is if we have that information. If we don't have it, then we will not be able to advise on whether the person is the right grantor necessarily, or whether the signatures even match the person's signature.
Okay. All right. How much does it cost to register a land?
Popular question. Because of, council told us about the stamp duty. The stamp duty is not a fixed fee, so I cannot tell you it's 5 cedis, 6 cedis, 10 cedis. It depends on what transaction you've entered, and also where the land is located. So within the same region, stamp duties vary. So if you take it from the oath is done at the court, so the court, so that is not usually much. You come and submit for the stamp duty, which is dependent on the value of the land, as I say, percentage. In some cases, some cases are nominal, like you indicated. Like some areas also are exempt altogether. like the allodial title as he indicated. So depending on which interest you are acquiring, it will attract a certain fee. The submission is now 80 something cedis, recently increased. It used to be 55, 45. But so you submit, then we assess the value, then you pay. Then for registration proper, also again, it depends on the size of the parcel. Usually, if it's one plot, the official submission fee should not be in excess of 1,200 or 1,500 pounds, right? If it's a transfer, the person has a certificate already and he's transferring. That's often cheaper because we believe we don't charge you certain costs. So with services, and I advise to people that if you want to know what the real cost of registration is, stop using middlemen all the time because they may come and mention figures and phantom human beings that don't exist. So they may say, oh, Mr. Timothy wants 500 CDs before he does X for you. You may add all that to your costs of registration. If you employ a professional to do it for you, that one, he will do it for you and charge you his consultancy fee. That is a different matter. But I can only speak to the official fees where we give you receipts, you pay, you get your receipts and you go. So then you can weigh what your actual cost of registration is per person.
Okay. Someone is okay. So this person says he missed the part, but where do I submit my indenture to initiate the stamp duty process?
Lands Commission offices all over the 16 regions. So we have the Land Valuation Division, which is part of the Lands Commission. So when you come to our premises, the Customer Client Service and Access Unit will receive the document and then transmit it to the division that does the assessment of the stamp duty, and then they will assess it and then they will let you know.
Okay. Um, okay, I think even so there's a question here, I think even I can answer. Says, please, is there any lawyer at all a person can consult about land matters? The answer is lawyers in good standing. Am I right, Mr. Mateka?
That is correct. That is correct.
Great. Lawyers in, and how do you find them? I think last time you
You
said you
just
can just
Google.
Google.
Google. You can
Yeah.
Google. It's on Google.
Okay. All right. Great. So I'm just curious, right? In all of our conversations, my mind just went to apartments because now apartments are springing up a lot by developers, and some of these apartments in the buildings are being sold. So how does it work if I'm buying an apartment within a whole apartment complex? How does it work? I'm not sure what my question is, but how does it
I,
work?
I am sure what your question is.
Okay.
So, so you are just trying to figure out what part of the apartment you'll be owning
Yeah.
and how it is sorted out. Yeah. So it all starts with the nature of the site plan that will be done for you. It's covered by a plan that we popularly call a strata plan. So it is describing within that building where you own. So if you're on, say, the second floor, your flat number is 52, your land, your flat area would become your land area. So for instance, there is something square meters is converted to hectare, acre. And the description for land transaction, the most important thing is the description of what you own. So you would have a schedule in the document which would also describe aptly the plan that has been. So we come and you register your position in that building and the interest that has been given to you. So if it is 50 years and they've given you that flat, we still have a method of representing that in our registry so that you would have a land title certificate, or in areas where there are no land title certificates, you have the deed registry or covering that flat that you own, and that will be your interest that you have in that land, parcel, piece of land.
Yeah. And to add to what Timothy said, he's absolutely correct. But to add to it, apart from flats and apartments, there's also a new concept that is becoming very common, condominium, and the law has basically addressed that. So when you read the law, section 81 onwards, it talks about the interests that are registrable, and it specifically mentions that condominium, flats, and apartments are now registrable under the Land Act. So you just have to follow the procedure that my learned colleague just stated, and then you should be good.
Okay, great. So so this question is also about land as gift. It says if a land has been gifted to you, you have your deed of gift, and you get a surveyor to make a site plan. What's the next step forward?
Okay, so if you so I'm very big on due diligence. Okay, it makes me uncomfortable when I'm talking. I want to start from the basics. So first of all, before the person you take it to the lands commission, you have to do your checks to find out whether the person has registered his or a title to the land. Registration is established that the registration has been done. Ensure that you recite the registration number in the recital. Even under the Conveyancing Act, there are rules on how you draft conveyances. And one of the rules is that if a document is registered, you have to recite the number and everything. So you recite the number in the deed of gifts, when the person obtained the document and all of that, everything about how the person came by their title. And then you attach the site plan to the deed of gifts. And then if it is I don't know the relationship, but if it is maybe a parent to a child, then you need to, I think, get your birth certificate. Timothy, please, if I stand to be corrected, but you need to add your birth certificate if you want the stamp duty to be exempt, because under the Stamp Duty Act, a deed of gift is exempt from stamp duty. So you have to attach a document to show that you are related. You is a parent to a child. Once you present that to the authority, they will stamp it as exempt.
All right. All right. Thank you. Let me see if there are any other questions here. Um, okay. Um, as we wait for more questions. Okay, as we wait for more questions. So is it safer to deal in lands in other regions than it is to deal with in Accra? Because I think someone sent in that question much earlier. Um, is it what makes it safer to buy land in other regions than it is here in Accra?
Okay, so it's it's a tricky question. Um, so there was a law which was um, repealed by the Land Act on deeds registration, and so all the only areas that are um, registration districts are for now Accra, Tema, I think Kumasi, and I think Eutu Senya, somewhere in the central region. And these are the registration districts. Now, with the registration district, the law is that it gives the holder of that document an indefeasible title in the absence of fraud. Because in law, when there's fraud, it vitiates everything. So it gives the holder an indefeasible title. Now, in the deeds registry, it doesn't say indefeasible title, it says priority. That's where I talked about the presentation. It says priority. So whereas the lands commission is talking about, hey, the registration districts give you an indefeasible title, the deeds registration gives you priority. So I would say that the title gives you more security than the deeds registration. But that does not mean that if you have the deeds registration too, it is not good. Like my learned colleague said, it is the highest form of registration you can get there. and it also gives notice to the whole world that you are the owner of the property, and therefore it serves the same purpose. But over there, I would advise that, in order for you to ensure that you secure your interest in land, you have to be vigilant. So I even advise some clients that, look, it's advisable for you to do a search even every year or every 2 years, just to find out what the status of your land is. Because if in a year or a few years down the line the search should recite something different, you can always write to the lands commission or the director of lands, who is the chief lands registrar, to rectify the record. And if the chief land registrar fails to do that, you can go to court and have the court compel them to rectify the record, because you have the records to show that at some point in time your name was there and it has been removed.
Righty. So there's a question here. It says, as a non-Ghanaian, what's the maximum number of years I can own a land for? Also, is there any minimum period of time provided under the law I can own the land, or is it just at the seller's discretion? If I feel the seller has been unfair to me in the number of years granted, what can I do about it?
Negotiate. So in Ghana, we, as a Ghanaian, you'll be entitled to leasehold interest mostly now, because Act 1036 also prevents families also from giving freeholds. So until 2020, freehold interest, that is giving somebody land freely forever, were granted by families, but now you can't. As for the stools, that had been stopped also long time ago by the constitution. So the only thing you have now for freeholds will be very rare if you have some individuals who may have that interest. So for a Ghanaian, the leasehold traditionally it's 99 years. I've heard people say you can get for 99 maximum, but I'm yet to see a law that puts a cap on the number of years you can have. All I know is that the law usually says you can have a terminable interest. It's just that we adopted the British maximum of 99, and it seems to be the norm. But it can be 60, it can be 70, it can be 50. As it's a minimum, unless the law also prevents you. So if you look in the Land Act, for some uses such as agriculture, it has some limits and some uses. So for agriculture, tree crops, it says 50 years. For cereals, it says 25 years. So you can be Ghanaian, but you want to enter cereal farming on the land. The law caps you to 25 years as maximum. You can want to enter ranching or cocoa farming, and the law will cap you at a maximum of 50. But for other uses, if there's no statutory limit on how long you can have it, then it's negotiation between you and your.
But let me add to what he said. This is also something that is in the law, but is a bit technical. So with a non-citizen, it's 50 years. Cannot get beyond 50 years. But you see, there's a magic year in the law, 22nd August 1969, which sometimes people gloss over. From 22nd August 1969, you cannot have a common law freehold in land in Ghana. From 22nd August 1969, a non-citizen cannot have a customary law freehold in Ghana. So it means that you can only have a leasehold. All right. Now with non-citizen, it is only 50 years, and there is no automatic right of renewal. So it means that if you want to renew, it has to be expressly stated in the agreement. But however, the law creates another two categories: indigents and citizens. So an indigent is somebody who comes from a place. So I'm from the eastern region, Kobodumasi to be specific. So if I buy land in that region, then it means that I can get 50 years, but there's an automatic right of renewal. Now, if you are an indigent, you are also entitled to 50 years, but you can also get another interest called the usufructory interest, which is forever. I hope this is not too technical, but I'm just trying to say that there are people who can actually get more than 50 years. That's what I'm trying to say. There are categories of
Okay.
people, but that category is an indigent.
Okay.
Yes, for what is worth, I mean.
Okay. All right. I think there's some more questions here. Let's see. Okay. I think this question we may have touched on, but let me just ask. We've seen cases where lands have been registered twice or having two title holders. Is this some act of negligence from the Lands Commission? Also, when a
Yes.
land in Ghana is gifted to someone, is that a freehold land or not?
No, so let me answer the Lands Commission bit first. That once there are two certificates, something must have gone wrong. It is not done. So there may be some error. It may be some level of negligence. The law is holding us more to responsible for acts such as these because it shouldn't happen once a certificate is granted. As I said, if there's not an overriding interest, then it's a success. So let's raise our hands where we are wrong and say that it shouldn't be the case. As for the gift, a gift, the person can only give you what he has. People should not assume that once it's a gift, it's forever. If I have a gift of 10 years, I can gift it to you. If I have a gift of 50 years, I can gift it to you. If you are a non-Ghanaian and I attempt to give to you more than 50 years, obviously the law will not permit so. So just understand that the person can only gift to you what the person has.
Okay. Mr. Matekole, did you want to add something?
No, no, he's right on
Okay.
point.
All right. Okay. Um, so this is are land guards necessary, and how do we get rid of them?
You don't need land guards. I'm laughing because it's a strange question. It's to ask whether robbers robbers are necessary and do we
Maybe,
need
I
them?
mean, maybe she's asking that because, she's seen influential people of high repute use land guards,
Yes,
to
yes.
some extent.
No,
So
I
yeah.
get it. It's just a phenomenon that we, because of insecurity of tenure, people tend to a certain regime of protecting what they have. And they believe that you need a land guard if a land is not in contestation. I don't think so. But it's often rife in areas where there's a lot of strife. It may be because there are two factions within the same family. It may be because two grants have been made to different people and they all want to flex their muscles. It may be there may be many reasons why people resort to that form of guarding their property. But the big advice is that it's a big risk to take because it can lead to bigger crimes. Also, the Act 1036 means that shows that if you took somebody to go and protect you presumed it was your interest and you interfered with somebody who was a legitimate owner's interest, you may be eligible for jail terms of 5 to 15 years, in some cases 7 years to 25 years if you are found guilty. If you are the one who put them there and they went to cause interfered with some legitimate person's interest, you may lead to some prosecution. It's not only the macho man, but it's the person who took them there, the people who incited, encouraged them to do that. They may be eligible. So please, people should be more careful with employing those methods of protecting their property. But as I say, you won't find that in a rural area. You won't find that even in the city where there is no strife. But where there is strife, then you hear issues such as these land guards happen.
Right. We're going to be wrapping up soon enough. But one of the questions that just came to mind was in Ramsar sites. And recently we've seen the minister issue out some stern warnings. How is it possible that people have possession of Ramsar sites and can sell them how do you even know that this site is, demarcated and shouldn't be bought or used? How is this happening?
Okay, so it has its antecedents in our planning laws. So we have declared places based on conventions that Ghana has signed all over the world to use places as world like heritage sites for birds and whatever in the wildlife. Now, the discussion is once the Forestry Commission people had found that these areas were Ramsar sites, it is the steps to take to protect them, because you can't just say they are Ramsar sites and go to bed. So I think we've all reneged in our responsibilities in protecting the areas designated as so. Because look, now the Minister for Interior was heavy on the one in Tema. Now we visited the site, we went there, people claimed they had documents. Not even one person could prove that they had a legitimately registered document for the buildings that they had built. Not one person. And that land was acquired for TDC. TDC is the title owner, but the people came with all kinds of documentation from purported pre-acquisition owners, chiefs, families. The difficulty is that I believe that between the TDC, the assembly, and then the Forestry Commission, they should have protected and stopped people from developing those sites. Because in the urban areas, once the land is available, people assume it is, and once they start building and nobody is preventing them from building, they assume whichever documents they have are legitimate. And I'm happy recently the new regional minister has declared all those areas as security zones. The assemblies then must be able to ensure that they are protected. And the example I set is Legon in Accra, KNUST in Kumasi, largely, and some of these big universities. In Cape Vast, for instance, you can see massive encroachments around the University of Cape Coast. Yet in Legon, you hardly find that. Why is that the case? Because Legon has a policy where every day its security men are driving around its boundaries. If you put one stone on a Legon parcel of land, you'll make sure that they've taken it away. So there's a responsibility of protecting these Ramsar sites. If we prevent people from building on it, we will not have any challenge. But if we say it with our mouth and we don't take steps to protect it, then you have the challenge of the encroachments that you see.
Right. Great. So, please, can you give a brief on the recent judgment case concerning the lands in Bauleshi, Oyarifa, etc.? The implication of acquiring land in that area if you've already acquired land, and the hindrances to your registration if you had land from the previous owners. I think we had an extensive conversation with
Yes,
Mr.
please. Okay.
Matekoli on this,
Yes.
yes, some time back. But do you want to like give a very brief overview on it and its implications for our listener?
Oh, well, it's just saying that there are areas of purchase. All that Senior Matakole has indicated, the background of your purchase. As I say, don't use general descriptions to describe your particular parcel of land. Somebody goes to an area and says, oh, this person got this document from this person, so it's comfortable for me to go ahead and get it. He does no search, he checks nothing. In Baleshi areas in East Legon, for instance, there are government acquisitions in some areas. There are challenges, and people should be careful not to follow the general stream and assume that it's so easy. And as I say, Greater Accra has its peculiarities because it's the capital city and because there's pressure here. If you were in other areas, you may not have the same challenges you have here. So people should just follow the advice that has been given earlier on and ensure that they make the correct inquiries before they proceed.
Right. So I think this person is referring to the Numo Mache judgment
That
on
he's dealt
the
with earlier on, so I'll allow him to do so.
right. Yeah. Mr. Matekoli.
Yes, sorry. I thought I'd already dealt with it. So okay, so well, look, I when we started, I indicated that um in a society such as ours, we cannot be timid. You have to participate actively. And so in that case, what happened was that a decision was given, I think so many years ago, in favor of the Numomashi family over a small piece of land. And then because they won, they used that judgment over the small piece of land to claim all the adjoining lands, measuring about 70,000 acres or so. You know, so when the issue in contention was 25 acres, they used 25 acres judgment to take over about 70,000 acres of land. So after going to the High Court, Appeal Court, Supreme Court, back and forth, eventually the court held that that particular acquisition, which was beyond the 25 acres that was given, was done fraudulently. And the witness that they also brought, they misled the witness, which is a surveyor. So, like I keep saying, in law, fraud vitiates everything. So once fraud had been identified, then there was no way of them retaining ownership of those lands. So the court indicated that those lands do not belong to them any longer. In fact, they never belonged to them in the first place, and that the decision. But however, I recall that there was a declaration or an order that they were not to enter. They were not to execute judgment, the judgment against those who are already in possession. So you have to take
Yeah.
note of that. That those who had an accrued interest, you cannot just go and say because today we are the owners of the land, they are coming to take possession. What you can do is you can have them atone tenancy to you, because if they don't atone tenancy to you, now they become adverse possessors. But it doesn't mean, and when they say atone tenancy to, it doesn't mean that you're going to sell the land to them. That was the warning I gave, because even though you have won a court judgment, they also have rights and interests in the land due to their possession. And my learned colleague rightly mentioned overriding interest, which I took very keen note of, because in our in this jurisdiction, a lot of in my practice, I've not seen lots of lawyers take advantage of overriding interest. But a person who is in actual possession of land has an interest which overrides that of a person who has a land certificate. So that is something that ought to be, looked at. That the fact that people are in possession doesn't mean that you ought to treat them like they are trespassers. They have a right if they have been there for a long time, for an interest.
All right. Great. So I think that we can start wrapping up. So I see that people have a lot of questions. Is there a way that maybe you can put your contact out so they can reach out if anybody wants to start acquiring, go through the land acquisition process, they can get through to you?
I think the chat, I can put it in the chat.
Okay.
Yes, I can put
All right. Yeah. So if you can put it there, then everybody else can access it and they can get in touch. But maybe I will take your last words. What are your last words, your advice to people who are beginning to encounter land litigation issues? How can they seek redress? What are the steps they can take? To people who are yet to get into it, what should they be looking out for? And then also, Mr. Anidoho, from where you sit, from the Lands Commission, what would be your last words as well? I'll start with you, Mr. Matikwale.
Okay, I think I'll basically just recap what I started saying, that in order to secure your interest in land in Ghana, you ought to engage a service of professionals. This is why, you see, our jurisprudence, our land jurisprudence is pluralistic, in the sense that we have the Constitution, which provides rules on land transactions. We have statutes. We also have the common law and other things, and the customary law. and sometimes some of these laws clash. So in order for you to ensure that you are secure, or you are protecting your interest in land, you ought to engage the service of someone who can help you navigate, this thing, so that when that is done, and you ensure that the lawyer gives his opinion in writing on it, you can use that to defend your interest. And also, I keep saying that whenever you are doing a land transaction, you ought to deal with the other side as though you are dealing with a dishonest person. They have to prove to you, based on the documents and their representations and all of that, that they are honest. But you presume that they are dishonest and have them prove to you with their documents that they are honest. That is the way you should proceed. Thank you.
All right, great. Mr. And before you come in,
Yes.
there's a last question here. Please let me put this last question across, and then you can give us your last words.
Yes, please.
Um, okay. There are two actually. Let me just. So, will land prices continuously be high and appreciating, or could it be static? Gone were the days where lands were relatively cheap, but now the prices are skyrocketing, even in some environments that are yet to develop. Is there any hope for the poor or average wage earner?
This is an interesting one. There's hope. I always say that what he's calling as cheap prices were relative to those times, exchange values and all that. They were not that cheap, I'm not sure. And also the population increase. But I believe if we have a better transportation network system, it may make commuting easier. Why are prices higher than some? It's only because getting to the CPD, which is the Central Business District, it's not the same for everybody. So somebody lives in cantonments, we all come around some area. He has a shorter distance, and that's what drives prices mostly. But it's a free market, so then now let's hope that the landowners themselves will be content with the money they are receiving, but they are also reacting to market conditions. If prices go high, why not? And there's population and there's pressure. So we all are looking for land to buy. Obviously, the prices will keep swinging in between. Whatever the market says, the price goes. We don't have any mechanism to prevent that.
So there's another one. Says that as a non-Ghanaian, are there any areas the learned lawyers would advise against investing in, possibly because of difficulty in ascertaining the true owners, higher litigation frequency, and any other issue?
Now I'll leave lawyer to speak about that, maybe. But just generally, it's not about non-Ghanaian. Whoever comes into the market must make sure that he's done his right checks and have the right professionals to guide them into the market. As I say, today may be a cool area not to litigate, but if some family head passes and suddenly there's a tussle about the headship, it may change. So is the right, for me, the advice is simple. Get the right professional, get the right advice at the beginning. Then you are safe.
I think he has answered
Okay.
the question. I think he has answered the question. That was exactly what I was going to say. Yeah.
Okay. So, UG, I guess the answer is that it's not even about what areas are great or you would advise against investing in or not. It's just about getting the right professionals from the beginning, and it doesn't matter in what area it is.
And,
Once you go get the
yes, and
professionals.
let me let me add that in the developed world, talk about the UK, the US, when land transactions are being done, the vendor doesn't deal directly with the purchaser. In some cases, the vendor's lawyer and the purchaser's lawyers are the ones who make payments and everything. The parties are only given the seller will only get his money at closing, and then the purchaser gets his keys. But the entire transaction is done by the professionals. And in the same vein, I mean, that is what you should expect from Ghana. It shouldn't be any different.
Okay. All right. So, Mr. Nido, you are going to give us your last words.
Just simple. People should just be encouraged to register. After they've gone through all the processes, there's no use obtaining a documentation and just hanging it in your room. And it's better to register when there's no pressure on you. You make yourself less vulnerable to charlatans and as a middleman and guru boys and whoever. If you want to register, register when you know that you have no pressure on you and you are patient enough with the process. Give Lands Commission the right phone numbers, the right addresses. Don't just leave your documents and say, oh, this doesn't matter, because we as public servants rely on a lot on your documents to be able to contact you if there's a challenge. And if you miss that, then you may have reasons where we want to contact you to help you to proceed with the process, and we may not get through to you. And hold public servants accountable. If you have a document here, it's been here for a while, there's nothing wrong with what approaching our offices and inquiring and asking, rather than relying on some person telling you some fibs when that may not be the position. So thank you very much.
Great. Thank you so much, Mr. Nidoho and Mr. Matikole. I think this has been really enlightening, and I'm so grateful for your time. I'd like to say thank you to everybody who joined us on this webinar. I hope that you've picked up a thing or two. If you have any more questions, you want to know what your next steps are for whatever situation you're in, I think Mr. Matekoli has put out his contact in the chat. It's 020-636-0997, Emmanuel Matekoli. And you can reach out and get the best help possible, and go through the due processes to get land, because land is great investment, and so be sure that you're putting your money into the right places. I'd like to say thank you to my team, to my bosses, Kelvin, Rashad. Thank you for helping to put this together. To my entire team, um, thank you so much to the entire staff of MIPASA. Thank you for all your help. And thank you all for once again for joining. My name is Daniela. I hope this has been a good session. So see you sometime again soon.
Thank
Thank
you. Thank you.
you.
Thank you.
All right. Bye.